Attorney General.
Madam President. Madam President, I beg to move the following motion standing in my name. Be it resolved that the House amendments to the Domestic Violence Amendment Bill 2020 listed in Appendix 2 be now considered.
Honourable Senators, the question is that the House amendments to the Domestic Violence Amendment Bill 2020 listed in Appendix 2 be now considered. Those in favour say aye. Aye. Those against say no. The ayes have it.
The amendment to Clause 10 as listed in the Appendix number 2 on the order paper states, Clause 10, delete all the words after the word amended and substitute the words by inserting after the word before the words during or after.
Attorney General.
Thank you, Madam President. Madam President, Clause 10 amends Section 9 of the Domestic Violence Act. And Section 9 of the Domestic Violence Act treats with the concept of a protection order being granted where one has an undertaking on the record. So Section 9 of the Domestic Violence Act treats with undertakings. The original law, as we have crafted it, says in proceedings under this Act, the court may at any time before the taking of evidence accept an undertaking from the respondent given under oath that the respondent shall not engage in conduct specified in the application or any other conduct that constitutes domestic violence. It goes on to say that where an undertaking is given under subsection 1, the court shall make a protection order or interim order as it deems fit in respect of the undertaking. We in the Senate had agreed with the recommendations coming from the wide group of stakeholders that we allow for that undertaking to be given only after the taking of evidence. And the focus group that proposed that were of the view that if persons were to receive the undertaking prior, some people may be intimidated by the fact of the evidence not being given fully. The four corners of the dispute would not be known. The Senate agreed, therefore, that we should only provide for undertakings after the giving of evidence. Upon passage of this in the Senate, we went to the House of Representatives, and members of the legal fraternity reached out. In particular, very distinguished member of the bar, Ms. Lynette Sibaran-Sweet, reached out and asked for a second thought. This was echoed by a number of the coalition entities, and Ms. Roberta Clark herself also reached out as well to indicate that we ought to take a phased approach to the law, and that perhaps we ought not to go so quickly into evidence after undertakings after evidence, but to allow instead for the undertaking to be given before, during, or after the giving of evidence. There is a great deal of merit with that approach, and therefore in taking a phased approach towards the law, it is sensible in all of the circumstances that we revert to the position of undertakings being given prior to the giving of evidence. We've bettered that position to say it may be given during the giving of evidence or after, allowing for judicial discretion. It struck me that that form of amendment would feed the separation of powers argument and preserve it, because for Parliament to say that an undertaking ought not to be received from a voluntary respondent until after the giving of evidence may have unwittingly destroyed the separation of powers principle, and therefore in all of the circumstances I think that the law has gone to work well in the Parliament, and I wish to express my profound gratitude to the members of the bar that reached out on this particular approach, and to say that of all the laws I've had the pleasure of drafting for the last 5 years, this one gave me one of the greatest experiences of joy, particularly because of the camaraderie that was exercised in the creation of the law. I want to thank the members of the bar. I want to thank the Office of the Prime Minister, the Children's Authority, the Attorney General's office, and the multitude of stakeholders for really coming up with what I think is excellent law. I beg to move.
Honourable Senators, the question is that this Senate agree with the House on the amendment to Clause 10 of the Domestic Violence Amendment Bill 2020. Senator Mark.
Thank you very much. Attorney General, the people that you have to thank, first of all, are us, members of this Honourable Senate. Without us, this bill would be not law. So I think that you must also take into account our presence and our contribution. Madam President, as I would not want to place any objection into this particular matter before us. I think the Attorney General, even though I just got it a few moments ago, that is not the order paper, but the actual invitation to engage in this deliberation as we are doing now. And I could appreciate the point that the Attorney General has made in the context of giving the persons, the respondent in this instance under Section 9, the possibility of providing evidence, right, or an undertaking, I should say, before, during, or after. And that would give greater flexibility in the context of the issuance of a protection order or an interim order. So we have all supported the legislation unanimously, we did, and I wouldn't want to in any way discontinue that in any way. So, Madam President, I support the amendment as proposed by the Attorney General at this stage. Thank you very much.
Attorney General.
I beg to move.
Honourable members, the question is that the Senate agree with the House on the amendment to Clause 10 of the Domestic Violence Amendment Bill 2019. Those in favour say aye. Aye. Those against say no. The ayes have it.
Private bill.
What page? Honourable Senators, the question is that a bill entitled An Act to Amend the Kabir Association of Trinidad Incorporation Ordinance 1932 be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Kabir Association of Trinidad and Tobago Incorporation Ordinance of 1932.
Honourable Senators, the question is that the Kabir Association of Trinidad Incorporation Amendment Bill 2019 be committed to the Committee of the Whole. Those in favour say aye. Those against say no. I think the ayes have it. The Senate shall now go into Committee of the Whole to consider the bill clause by clause.
Clause 1.
The question is that Clause 1 stand part of the bill. The question is that Clause 1 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2.
The question is that Clause 2 stand part of the bill. The question is that Clause 2 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 2 now stands part of the bill. Honourable Senators, the question is that the bill be now reported to the Senate. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate. Honourable Senators, the bill having been considered in Committee of the Whole and approved without amendments, the question is that this Senate agree with the committee's report on a bill entitled An Act to Amend the Kabir Association of Trinidad Incorporation Ordinance 1932. Those in favour say aye. Those against say no. I think the ayes have it. Honourable Senators, the question is that a bill entitled An Act to Amend the Kabir Association of Trinidad Incorporation Ordinance 1932 be now read a third time and passed. Those in favour say aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Kabir Association of Trinidad Incorporation Ordinance 1932.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I beg to move that the Senate do now adjourn to Tuesday, June 30th, that's tomorrow, 2020, at 1:30 p.m. During that sitting, we will complete the committee stage of the Urban and Regional Planners Professions Act 2019.
Honourable Senators, before I put the question on the adjournment, leave has been granted for two matters to be raised. Senator Mark.
Thank you, Madam President. The first matter that I would like to address is the failure of the government to settle collective agreements in the public sector over the past 4.5 years and its impact on the quality of life of the workers. Madam President, workers all over Trinidad and Tobago are expressing regret at having voted for the PNM government. This government has squandered the wonderful platform that the People's Partnership government left when we settled over 100 collective agreements valued at over $3 billion, bringing up to date and ensuring that workers could comfortably take care of their family. The workers are now asking, the government rather, they are now asking, I should say, the government is now asking rather, the workers to measure their success on the number of consultations and symposia, but not a single collective agreement has been settled over the last 4.5 years. And with the rate of inflation averaging just under 10% during the last 4.5 years, it means that the workers' pay has been diminished by about that same percentage, Madam President. Is it that the government wanted to punish these workers during the period that they have been in office? Is it that it is a wish of the government to push these workers down based on their bad decisions given by persons like Malcolm Jones, which resulted in tens of billions of dollars in debt, in addition to the debt incurred by others in this Rowley administration? Madam President, if we compare our total debt to what the little they will leave from our savings, we may very well be considered bankrupt. This government has kept public servants and employees of state enterprises and agencies on full pay during the lockdown only because it is an election year. Otherwise, they would have been laid off without pay, as most have been in the private sector. They want to call the election so they could use the COVID-19 as their campaign platform. But they are becoming very anxious that a massive protest planned by workers for pay increases can derail the fragile COVID-19 platform. Mr. Vice President, workers know when is the best time to protest during this government's reign. In fact, they know only too well by protesting they can get results from this government. The PNM finds itself in a catch-22 situation. Should it call a snap election by the middle of this month, with workers marching for peace, bread, and justice? Or should they call the elections later and risk the dissipation of the novelty of COVID-19 campaign wearing thin? Mr. Vice President, what will they tell you about your salary negotiation? That is the workers. When they come looking for votes, it is the same old blame Kamala, blame falling oil prices. And Mr. Vice President, if you make the mistake and vote for the PNM, we are predicting a wage freeze, retrenchment, closures, and heaven forbid, Mr. Vice President, you may have major wage cuts as occurred in 1987 and 88. In 2010, we developed a database of all collective agreements and took proactive measures to ensure that none was left behind. We communicated regularly with all state sector companies and agencies. We insisted that they move forward with their negotiations. And if they could not settle bilaterally, we took steps at the Ministry of Labor to bring them in for conciliation. The OWTU and TNTech will remember when they got stuck at the bilateral level and the workers were becoming restless. We did not wait for a report to be made. We intervened in the dispute, and when it became protracted, we quickly referred to the industrial court, the matter where it was eventually settled. Mr. Vice President, we were quite honest in our dealings with the unions. We did not hide from them the financial status of the country. You may recall when we could have afforded to pay only 5%, we settled with the PSA at 5%. And later, when we could have afforded 9%, we were honest in settling Petrotrin and others at 9%. But we also went back, and those who had been settled at 5% were upgraded to 9%. Mr. Vice President, the PNM, under the outgoing Rowley administration, has settled not one agreement. It only came to take away from the workers bread from their mouths. The PNM has spent as much, if not more, than the partnership over the 5-year period. So why they did not pay workers their well-deserved salaries? They needed it. These workers needed it badly to pay their children's education from the loss of gate. They needed it to pay for increased prices for food. with the reinstatement of VAT. They needed it to pay for private health care services, since the healthcare sector is unreliable. They needed it to pay for transport because gas prices had increased several times. And to the workers' credit, they did not riot. Mr. Vice President, the government spent our taxes. They used the HFS savings. They borrowed heavily from international institutions. They mortgaged to the Chinese. Why they did not pay workers their just dues? The nurses are fed up and recently reminded us that the previous occasions that they marched in 1981 and 1990, significant things happened in this country. And in Tobago, the PNM is justifiably accused of creating a dependency syndrome, with more than half of the working population dependent on taxpayers' money. Mr. Vice President, look at the budget over the years. The government had money. Why they did not settle a single collective agreement? There is a feeling among some unions that the PNM is anti-worker and has been engaging in union-busting strategies. To use Petrotrin as an example, the closure of Petrotrin would have effectively removed the most powerful OWTU and its capacity to function as a political pressure group when required. The PNM has been consistent in its emasculation of powerful unions that shape the political life and in.
I can't believe somebody wrote that. First, let me correct Senator Mark's usual inaccuracies, flights of fantasy, figments of his imagination. The inflation rate in Trinidad and Tobago is not 10%, it is 1%. Senator Mark tends to just make up these numbers as he goes along. In addition, the former administration increased public expenditure from 46 billion in 2010 to 64 billion in 2014. This administration has managed to keep the country running on an annual expenditure in the vicinity of $50 billion. So it is just wrong to say that this administration has spent the same amount of money as the former administration. We have in fact reduced expenditure by 20%, or approximately $10 billion per year. Coming now to wage negotiations, the former administration, on the eve of the 2015 election, entered into a number of agreements with various trade unions, gifting the incoming PNM administration a back pay bill of $6 billion, which we have paid. It wasn't easy. It was very, very difficult, because having ballooned public expenditure up to $64 billion and with a total collapse of energy prices in the 2014 to 2015, 2016 period, we suffered a loss of $20 billion in revenue on an annual basis. Notwithstanding all of that, we still managed to pay the back pay of $6 billion. I would like to inform honorable senators. I really don't have really much to respond to Senator Mark's rhetoric. Let me just inform honorable senators what it will cost Trinidad and Tobago, what various wage increases would cost if an increase of 3% over the period 2014 to 2016 was paid at 1% per year, with consolidation of COLA and the salary and allowances that have been determined by the Chief Personnel Officer to be justifiable, the cost would be $3.8 billion. And I'm speaking to honorable senators. As I said, I don't have much time for Senator Mark. So I want to repeat that. If an increase of 3% over the triennium at 1% per year with the salary and allowances that the CPO has determined to be justifiable, that will cost $3.8 billion. What I can also say is that pre-COVID, the Ministry of Finance had submitted a number of submissions to Cabinet with respect to settling of collective agreements and making recommendations. And pre-COVID, we had prepared a proposal to start discussing the question of improving allowances for public servants. And might I add that the estimated manpower, the workforce that we are talking about, is 89,000 workers, which essentially comprises civil service, statutory authorities, the Tobago House of Assembly, the protective services, defense force, police, fire, prisons, daily paid group, the various local government corporations, and others. The total number of workers is 89,000. And just prior to COVID, in March, the Ministry of Finance had begun the process of starting to meet and treat with the unions to discuss improving allowances. The cost of that was estimated at $765 million. But we were prepared to do it. We were prepared to start the discussions. However, I'm afraid that COVID caused that matter to be deferred, because as everyone in Trinidad and Tobago will know, COVID has caused us to lose about $10 billion in our annual income. So we as a country have to be very, very careful. I know the other side may wish to promise the sun, moon, and stars, but I wish to warn the population that the other side's economic plan post-COVID is a massive devaluation of the Trinidad and Tobago dollar, which we do not intend to do. Thank you, Mr. Vice President.
Senator Mark.
Thank you. Thank you. Mr. Vice President, the other matter I wish to raise deals with the need for the government to outline step by step the process used by the CDA in its recent filling of the position of General Manager. And I raised this and I put questions to the relevant minister. Mr. Vice President, the first question is, how long has the General Manager of the CDA been acting? On what basis was the acting General Manager given preference to act? Is there a family relationship with the current acting General Manager and the Prime Minister? Is there a family relationship between the current acting General Manager and the wife of the Prime Minister? What are the qualifications of the current acting?
Senator Mark, 1 second. Again, as much as it matters in the adjournment, the commentary and the line that you're going down is becoming dangerously close to imputing some improper motive in relation to the appointment of the particular individual to that institution. I would caution you strongly to be careful the line that you're going down.
Mr. Vice President, we are doing taxpayers' money. Was there any senior members of staff who were overlooked for the position of acting General Manager and that person sent to Plibdeco? The person who was acting before, was that person sent to Plibdeco, Mr. Vice President? and why? Is the deceased husband of the acting GM the cousin of the Prime Minister? Is the acting GM, that is the general manager, the sister of one Sharon Rowley? How long has she been working at the CDA? What are the terms and conditions
Standing
of
order.
employment?
Senator Mark?
I rise on standing orders 48-4, 46-4, and 46-6. I think my friend needs to bring a substantive motion against the Prime Minister. This is not an appropriate forum to impute improper motives. I ask for your ruling.
So, Senator Mark, as I indicated earlier, and I'm going to uphold the standing order being raised by the Honorable Attorney General, the commentary that you're raising in the matter of adjournment is or can be taken by the average person listening to mean that there's some improper motive taking place by what you are saying, Senator Mark. So I am ruling that you are in breach of the particular standing order as it relates to imputing improper motive. If that is the entire argument that you're bringing forward, then I'm going to ask you to move on if you have any other points in relation to the matter of the adjournment.
Mr. Vice President, I'm dealing with taxpayers' money, and this is not no private individual that we are talking about here. We are talking about taxpayers' money, and I think that, for instance, without
46-4 and 46-6, I'm talking about a member of the House of Representatives, which our standing order treats with, Mr. Vice President.
well, you have ruled already, so let's go.
So, Senator Mark, again, I have cautioned.
May I continue, sir? I understand what you're saying, sir.
So I have cautioned. You are not to go down that road of the argument that you are putting forward now. There is a matter in the adjournment that you have put forward, which you are making a case for, but that argument is in breach of the standing orders raised. If you have another argument in relation to the matter in the adjournment, bring it forward now.
Mr. Vice President, I am raising a matter in which I am seeking to find out what are the terms and conditions of engagement of the acting general manager of the Shagaramas Development Corporation or authority, rather. Mr. Vice President, you must know that the former acting general manager of that authority left on the 1st of March of this year, 2020, and a new acting manager started to act on the said day, the 1st of March, 2020. And what I'm asking here is that this portfolio of the CDA is one in which there is plenty state property, land on the Western Peninsula. And therefore, I am asking, as a senator, whether, for instance, this process was above board. I'm asking for transparency. I'm asking for accountability. I'm saying that the government needs to account to this country as to how this individual arrived at the post of general manager, which I'm entitled to do, Mr. Vice President. And I'm not imputing any improper motives, sir, against anybody. I'm just asking questions. So I am asking, Mr. Vice President, whether these individuals, first of all, if the Attorney General is going to respond, let him tell this Parliament what are the qualifications of this individual who is the acting general manager of this particular important institution. Whether there was one, the Owati Dilraj Batu Singh, who was acting as general manager for a number of years, why that person was not allowed to continue to act. Why was this individual, Mr. Vice President, sent off to Plibdeco? Was it to create a preferred incoming candidate?
What I'm saying, what you've just said borders upon imputing improper motive. And I'm just going to point out that the matter in the adjournment as filed speaks to the process by which a general manager is appointed to the CDE. And what you're actually saying is that a particular individual is appointed and you are questioning the individual and the connections that they may have. Hence the ruling that you are imputing improper motives. You only have 3 more minutes yet on the matter of adjournment. Again, if that is the argument, I'm going to ask you to desist from that argument and stick to what is filed in the matter of the adjournment.
I would like to ask, through you, Mr. Vice President, who confirmed the acting appointment of this general manager? Was it the board of directors? Is there board minutes that the AG, who might be responding, able to produce to substantiate this matter, Mr. Vice President? Mr. Vice President, this is a matter of public interest, and that is why I've raised it. So I've asked, through you, to the government to answer. We want to know the process that was involved. We want to know how this person was recruited. We want to know if there was advertisements made for this particular post, because this is a very important post within the CDA. And I don't want to burden you any further. We have a general elections. And if the government doesn't answer us here, they will have to answer us on the campaign trail, Mr. Vice President. This is a very serious matter. They accuse this PP and ourselves, Mr. Vice President, of nepotism, favoritism, corruption, that the Kamla Prasad Bisasa administration, thief, and they use all kinds of things. And when we come here with a motion to deal with reality as to what is taking place at the CDA, everybody's jumpy, everybody frightened, everybody saying improper motives, Mr. Vice President. All I ask for is answers to this question on behalf of the citizens of Trinidad and Tobago. And if they don't give us straight answers, I give you the assurance, Mr. Vice President, answers will be given to the public when they call the elections on the 9th of July for the 17th of August. We're waiting for them, and we'll lead them raw. Thank you.
Minister of Agriculture, Land and Fisheries.
Mr. Vice President, were it not for your many interventions, we would not have gotten the 1 minute when Senator Mark actually spoke to his motion. And perhaps, Mr. Vice President, we should advocate for the word factitious to be included in the dictionary. Factitious. It's something that sounds like a fact, but it's really fictitious. Because, Mr. Vice President, the government came here to answer the motion. And even Senator Mark throughout, it's almost like a repo farmer all over again. Throughout his motion, he spoke to the uselessness of the motion. Because the motion asks about the step-by-step process for the CDA in its recent filling of the position of GM. Well, Mr. Vice President, Senator Mark, and this is no allegation, I knew when he was in the leadership of the trade union. He was a research officer. I consider that to be in the leadership. He wasn't high up, but he was there. And you must know that you cannot fill a position and have someone acting in the position. So the position is not filled. In answer to the motion, I would say there is no recent filling of the position of General Manager at CDA. There is no current filling of the position. There is a vacancy, and a process has been undertaken to fill the position. So that's the first thing. There is no filling. The second thing, Mr. Vice President, is that in his war of words, he's attacked several individuals, including the former general manager. So I want to place on the record, Mr. Vice President, that Dilraj Batu Singh was not the acting general manager and was not moved out to make room for anybody. Ms. Batu Singh was in fact confirmed as the general manager. She held the position of general manager, having previously held legal positions in the authority. She resigned in February 2020, and her resignation was due to take effect on March 31st, 2020. The board's term of office was coming to an end on March 15, 2020. So Ms. Batu Singh resigned on her own volition to take up a position in Plipdeco. Faced with the resignation of the general manager, the board had to put someone to act as general manager. And Senator Mark knows. He knows how it works. CDA is a unionized environment, Mr. Vice President. If anything had gone wrong in this process, you would have heard it from the PSA, not from Senator Mark. So that, Mr. Vice President, the board, having received the resignation and facing the end of its own term, placed an advertisement for the position on March 4th, 2020. That is within days of the resignation of Ms. Batu Singh. The advertisement was placed on Caribbean Jobs on March 4th with a closing date of March 11th, 2020. Mr. Vice President, in line with well-established procedures, especially in a unionized environment, the person identified by the board of directors to act in the position of general manager was the person who was the next most senior person in the authority. That person, Mr. Vice President, was recommended by the outgoing general manager. As I said, Ms. Batu Singh's resignation was due to take effect on March 31st, 2020. This is in the early part of March. An advertisement placed to recruit a substantive GM. March 4th, closing on March 11th. Board leaving on March 15th. And the outgoing nominating the next most senior person in the organization in line with collective agreements, good industrial relations practice. That is how it's done, and Senator Mark knows that. Mr. Vice President, at the third special meeting of the board held on March 5th, 2020, the board, noting the recommendation of the outgoing GM, noting that the person was the most senior person after the GM, noting, Mr. Vice President, that there was support from the representative union, the Public Services Association, the board agreed to the acting appointment of someone as general manager. Since then, Mr. Vice President, the recruitment process has yielded 94 applications by the closing date, March 11, 2020. There was an interruption in the process on account of the COVID regulations. The board itself went off on May 15th. On April 17, 2020, the board was advised of its reappointment, and on June 22nd, the CDA returned to full operations and will now proceed along the lines it had set out. In early March, when the position was advertised, it will now proceed with the 94 applications received to identify if there is a suitable candidate to fill the position, to use the words of Senator Mark's motion, to fill the position of general manager. Anything outside of that, Mr. Vice President, is factitious. I thank you.
Honorable Senators, the question is that this Senate do now adjourn to Tuesday, June the 30th, 2020 at 1:30 p.m. Those in favor say aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Tuesday, June the 30th, 2020 at 1:30 p.m.